broadcast is now starting. All attendees are in listen-only mode.
Good afternoon and welcome to Labor Law 101, what employers need to understand about the National Labor Relations Act. Thank you so much for joining us. I am Nichole Atallah. I'm a partner here at Pleroma, and I'm here with my colleague, Sarah Nash.
Hi, everyone. I am an associate here in the Labor and Employment Group.
I noticed because I was looking at stalking the list, many of you we know, so thank you all for joining us today. And for those of you who don't know much about Pleroma, we are a full-service law firm with offices in both Washington, D.C. and Boulder, Colorado. In addition to our government contracts, corporate and litigation departments, you have Sarah and I who practice in the Labor and Employment Group and are very, very happy to get to share some time with you today. We realize your time is valuable, so we're going to try to stay on schedule today. This is the first of a three-part series. At the end of the slides, we have the dates and titles of the other two. But really what we want to do today is lay the foundation for what you need to be thinking about when you're thinking about the National Labor Relations Act. And one of the first questions I usually get is, well, this only applies if I have a unionized workforce, right? Wrong. This applies to all of your employees in different ways, certainly, but it does apply to any employee regardless of their union membership. So today we want to familiarize you with the types of things you need to be looking out for, the types of things that we see that raise red flags for us. We want to let you know what rights it gives to you as the employer versus what rights it gives to your employees so that you can navigate these issues when they come up. And then identify where this could possibly go wrong for you. Even if you don't have a unionized workforce, where could this expose you to a little bit of risk and liability?
So what is the National Labor Relations Act? It was passed in 1935 and was intended to address an equality of bargaining power between employers and employees. And basically what that means is it allows employees to form groups and organize together so that they can kind of have equal bargaining power with the employers. That was the idea behind it. And there's a lot of labor history that went on before that point, but in 1935, Congress decided that they wanted to legislate it and make it a federal sort of overarching value that they have. Now, this just legislates for private sector employers and employees. It doesn't apply to the public sector, which are covered by various state laws and the federal law for the federal workforce. And it's kind of evolved over the years, but essentially what we're going to be talking about today is the very sort of basic guidelines of the law, how it applies, and what this might pop up in your general workforce. One of the biggest sort of guiding features of the Act is that it ensures employees can engage in quote-unquote concerted activity. And it's a pretty straightforward idea of what concerted activity is, but there are some requirements. First of all, it has to be between two or more employees. That's the concerted part, which means if an employee is just sitting around on their own, talking about their own rights, it doesn't count. It's not protected. But the minute that that employee joins together with one other employee or is advocating on behalf of another employee, it generally becomes concerted. And that activity can relate to talking, organizing. Sometimes employees will want to organize together to form a union when it comes to voting for a union, when it comes to soliciting authorizations in order to get to a union vote. These are the sort of things that employees are engaging in. And it's not just in this general union realm. It also applies more broadly. For example, recently, we've had the board, for example, say that it's unlawful to ask if employees have previously litigated against their employer, just because the idea is that employees can group together in class actions, and that could potentially be encompassed by the Act.
And that would go, like, even if you're Google searching a potential applicant, that's something you'd want to be careful for, because we do get calls in our office, and it's, we made this offer of employment to this person, and we went out online and we found out they were a party to some sort of class action lawsuit or some other lawsuit. There, not only are there state laws that might protect that person, but that the NLRA is also something that you'd want to be careful about there, because that, especially in a class action situation, they've joined together. They might be talking about the Fair Labor Standards Act. They might be talking about their wages. Before I forget, I'm going to let Sarah go on, but we are taking questions. So feel free to submit your questions as we go along. We will try to answer them as we go along. And if we don't get to them, we will respond to you. So I'd left that out at the beginning, so I want to make sure I covered that.
Yeah, so that's sort of the broader bounds of what the Act relates to, concerted activity. So if you can just keep that in your mind as we go through these, ultimately the Act is protecting employees who want to engage in this sort of behavior. It also sort of regulates which employers and employees can form collective bargaining relationships and collective bargaining kind of negotiations as they go through the standard union-employer relationships. And so one of the future webinars that we're hosting is going to go over the specifics of negotiating and really do's and don'ts and what you need to remember, because there are some things that you really can't say and some things that you should say, but we'll get into the weeds of that at a future webinar. But it's just good to know that generally the way that you negotiate with employees and with their collective bargaining representatives, also known as their unions, is important. And one sort of last thing to note is that this is all regulated by the National Labor Relations Board, which is a board that right now I believe it has 3 members.
Yeah, the chairman is nominated but not confirmed, which was, if you follow this type of thing, there's some drama about how that deal was struck, because some business-friendly folks are not happy that this particular former chairperson is now being renominated. But yeah, it's inherently a political body, because so many folks are appointed by the current party and
the current administration.
Generally,
they're well defined by Republican versus Democrat. And so it's the separate board. They have many different regions across the United States, and within those regions, they are responsible for investigating union, employee, and employer claims that might come in. And you should also remember this is different from the Department of Labor. They both have the word labor in it, but this is dealing with the union and employee rights side. So part of what the Act does is it specifically protects employee rights. And whether or not employees are represented by a union, sort of what we talked about earlier, protected concerted activity is protected under the Act. And some of the examples of this include organizing for a union, forming a union, joining or assisting labor organizations in working towards that goal, collective bargaining for changes in terms and conditions of employment. And terms and conditions is sort of a technical term, but it pretty much applies to any sort of wages, benefits, working hours. Generally, if it impacts the employees in a way that touches on any of these main pillars, then it's a term and condition of employment. And then it protects them if they engage in concerted activities. And not only does it protect their ability to engage in these activities, but it protects them to make the decision to refrain from engaging in those activities. Sometimes you will have employees, for example, who don't want to participate in organizing or choose not to vote for the union, and that is just as equally protected as vice versa.
So the other big section that there are obviously more sections in Section 7 and Section 8, but the reason why we're hitting on these is because these are really the heavy hitters, right? They're really where a lot of the rubber meets the road with the NLRA. So Section 8 really goes to restraints to the employer, right? What can the employer not do? So Section 7, we talked about what employees have the right to do. And now we have to talk about what employers cannot do. So if you, as an employer, we're getting wind that, folks might be organizing, or folks might be upset about their wages or something like that, anything that you did to interfere with or restrain or coerce employees would be, in exercising those Section 7 rights we just talked about, that Sarah just talked about, that would be unlawful. So, there are the famous stories of, kind of decades past where we say, oh, this doesn't happen anymore. But you would have basically employer henchmen out there, threatening employees, like, don't unionize, or you can't talk about this. You also, Sarah and I see frequently policies and handbooks that arguably run afoul of this particular issue. You can't talk about your wages with other people. That could be construed as a restraint on an employee's right to engage in those Section 7 rights. So you want to be very careful in how you communicate these types of workplace rules. And we'll talk specifically about how all of this translates into workplace rules here in a second. But this comes up often with organizing as well. When you hear about employees who are organizing and you say, well, maybe I'll just try to give so-and-so a raise and kind of knock them out, right? Some of that type of conduct, some supervisors that maybe are a little bit gruff with employees, or it might appear threatening. It's not often these days that I see direct threats, but I see a lot of indirect type of conduct that can run afoul of this. And that kind of goes to the second point. You can't interfere with the formation or administration of a labor organization or contribute financial or other support. So you can't try to stack the deck, right, so that employees like you, or that you try to influence organizing in one way or the other. You can't get involved in that process, which is really, really hard to do, especially because you as an employer are going to have strong opinions about those types of activities happening on your work site. So it's really important to understand kind of the limits of what you can say and what you can't say. Now, it doesn't mean you can't say anything. It just means that what you decide to say or what actions you decide to take fall within the confines of what you should be able to do.
The other thing that it deals with, and I'll just touch on this briefly, is this idea. Sometimes it probably doesn't come up that often, but sweetheart unions have historically been a problem where an employer, for example, maybe there will be a couple of unions who are vying for employees' attention, and the employer will say, no, I like this union for whatever reason. Maybe you trust their policies a little bit more. You like working with them. The act really tries to stop that sort of behavior. It doesn't want you to engage in some sort of incestuous behavior with a union that essentially means that you and the union are on the same side and maybe looking out for each other and not looking out for the employees.
Which makes sense. If you're financially supporting or otherwise supporting one particular union or group, it's going to interfere with that employee's relationship with its bargaining representative. So it does make sense from a policy perspective. It doesn't always make it easy for employers. You also can't discharge or discriminate against employees because they're engaging in these activities. So where does this often come up? You know somebody was involved in union activities, and so you don't want to hire them because you're afraid that they might organize. We see that a lot. I get the question all the time, at what point in time do I ask somebody if they are involved in a union, or at what point in time should I tell them that we have a union on site? And, I strongly discourage you from doing any of that kind of thing prior to making an offer of employment. Now, they might want to know that there's a union on site before they accept an offer, but you certainly don't want any information about how they feel about the union being on site prior to making a hiring decision. And that you find out information in lots of different ways. The internet is a powerful thing, and a lot of us Google employees and figure out their political activities or their union involvement, any number of personal characteristics and attributes prior to them being hired. The question is, when should you do that? You also should not fire somebody because they've talked to another employee and they've gotten together and they decide they should all have raises, right? Wholly unrelated to union activity particularly, but it relates to that Section 7 activity. So, be careful before you make discharge decisions when somebody's complained about something or has, with another person. And what I would encourage you to do is to seek counsel if somebody's complained and then about something like a term or condition of employment, and then for whatever reason you want to terminate them. That's a risk factor that should run right up alongside any, EEOC risk or, whistleblower risk or anything else. That's one of the things that you should be evaluating. So generally, and we'll talk about what an unfair labor practice is at the end as well, but usually we see these kinds of violations or discrimination happen because, somebody files a ULP at the NLRB and employers are angry. So all of a sudden they start getting written up or terminated. You see that happen. They are cooperating in investigations or testifying in investigations that involve this type of protected concerted activity or a complaint against the company. And if you discriminate against somebody on that basis, treat them differently than you treat other employees that have engaged in similar conduct, that can be a high-risk situation for you.
Mm-hmm. And I'll just add that this doesn't mean that you can't necessarily fire people who have engaged in this activity. You just want to be really careful that you have legitimate, non-discriminatory reasons for doing so. And the ways that you can make that most likely not unlawful is to make sure that you have clear disciplinary policies, that you're administering those policies in an equal and regular way. And so there are ways to sort of paper your decisions. You just don't want to be caught sort of, not necessarily following those policies.
Yeah. So for example, if you say, well, Joe was late to work today, and so I want to fire him. Well, if you don't have records that you fired anyone else for being late to work one time, that's going to be a huge uphill battle for you, right? Because chances are you've had other employees that have been late for work. Now, if you say, we have an attendance policy, and the attendance policy says if you are late to work 5 times in any given month, that's grounds for termination, and we have records to demonstrate we have terminated other similarly situated people, then maybe you have an argument that, that you have a legitimate reason for termination. Those are the kinds of things we're checking. So we covered this a little bit, but basically the same thing applies for hiring, tenure, any other term or condition of employment. So think of this a lot like you think of EEOC discrimination issues, right? You need to treat people the same way regardless of whether they've engaged in this protected concerted activity. Some of the hard questions usually become when you get that rebel rouser, on site, and it seems like that person has taken up the charge for organizing, or they're all of a sudden complaining a lot and they've certainly taken up a cause. Sometimes that does happen to coincide with that person also taking liberties with the rules. And that happens sometimes. But again, we're just trying to be very careful that our opinion of them, because they're causing some issues for us, is not being skewed by those issues, and we're really treating them the same. The Labor Management Relations Act, this next part is really a point of confusion about what a closed shop is, what is an agency shop, what's a right to work state. So one of the common questions we get is, but we're a right to work state, right? And that's often confused with at will employment, which is we can terminate somebody for any legitimate lawful reason that we want to terminate somebody. That's very different than a right to work law, which basically says that an employee does not have. Let's start from the basis of employees do not have to join a union, right? Let's start there. Employees never have to join a union. But in certain states, they may have to pay fair share. They may have to pay fair share fees,
also known as agency fees.
Also known as agency fees. And in some states, if you have an agreement with a union, there are questions about whether do I have to terminate somebody if they don't pay their agency fees or if they don't pay their dues if they're joining the union. And that's really what it comes down to when you're talking about closed shops versus agency shops and right to work laws. So if you have questions about which states have which, and you should look at them, because if a lot of times I see agreements, we'll see collective bargaining agreements, and we'll look at the clause in the collective bargaining agreement that covers this. There'll be agency shop or closed shop. There'll be language in that agreement that covers what the rules are with respect to continuing to employ somebody if they're not paying their, fair share fees or agency fees or dues. And sometimes they get it wrong. Sometimes the language in there is either old language, it's never been updated when the right to work law was passed in that state, or sometimes it's just that the union wants you to agree to a little bit more than you have to do as a matter of law. So you should be looking at those clauses to make sure that you understand what your obligations are with respect to continuing to employ folks depending on the state that you're in.
So I touched on this a little bit, but the idea of collective bargaining. So bargaining is also covered specifically under the Act, and basically what it provides is that employers are required to meet at reasonable times. That means they can't just say, oh, I'm only available once every other Thursday between, 7 a.m. and 8 p.m. It has to be reasonable times to confer in good faith with employees, designated bargaining representative on mandatory subjects of bargaining. And there's a lot to unpack there, but the sort of buzz items are good faith. When you show up at negotiations, you have to essentially be looking to reach a amicable agreement with the union. You can't just go through the motions, sit there and say, oh, yeah, no, that's not going to work. No, it's not going to work. You have to actually be trying to work towards something. And it's really hard to prove this. And chances are that it's not going to be able to be shown that you weren't operating in good faith. But this is an element that exists there.
It also, because of that ambiguity, it's one of the first unfair labor practice charges you get anytime that you're engaged in negotiation. The union doesn't like the pace, or they don't like, whatever's been going on, or they feel like you're not really trying hard enough to give them the raises that they want. And all of a sudden you get an unfair labor practice for failure to bargain in good faith. Mm-hmm. And I'd also add at this point that it doesn't necessarily have to be a formalized union. It could be, it's more common that you see it that way, but it could be another type of bargaining representative. It could be more informal than you're used to seeing. Mm-hmm.
Then we have a question. Does the union have to confer in good faith too? Yes, they also have an obligation. It goes both ways. The employers are just as able to submit ULPs to the board. And so if you have trouble with the union, you're more than welcome to submit.
You don't see it as often because usually the company doesn't want to pay for those types of things. Mm-hmm. And usually the company is less in a rush to get the CBA signed, sealed, and delivered. So if the union wants to stand up and walk out, okay, sayonara, you see it less. But as we'll talk about next week, you might be under time pressures because of a government contract deadline. And if it's not proceeding the way it needs to proceed, or the union's threatening to go on strike, but they're not engaging in good faith, you might have a reason to go forward with the ULP as an employer.
Absolutely. And the other thing is to remember is generally when you're negotiating these agreements, the status quo is going to be less expensive than the ultimate CBA, because if not, why would employees ever agree to ratify these things if they weren't actually going to get wages increased or benefits increased? And so generally it's in the union's best interest to get to a reasonably quick agreement. The last sort of piece of all of this is the mandatory subjects of bargaining. There's a lot of different cases out there that decide what's mandatory and what's not, and this will come into play in one of the future webinars. But essentially knowing what you have to bargain about and knowing things, they're known as the opposite to mandatory is permissive. Permissive subjects of bargaining, you're not required to bargain on them. So there are some things that you absolutely, wages, for example, benefits, those big ticket items that are clearly going to be directly within employees' terms and conditions of employment. And so you can kind of break the duty to bargain into other sort of mini obligations that employers will also have. One is that employers have to deal with whoever is designated by the employees to conduct the negotiations. Whoever the employees have decided this is our bargaining representative, the employer is obligated to sit down with that group. And generally, they have to let who they want in the room into the room.
Yeah, and we get a lot of complaints. We'll get clients that say, I don't want to sit down with that guy. He was a complete jerk the last time. And
oh, yeah.
So we get that sometimes. And unfortunately, we don't get to dictate that, but they don't get to dictate who we bring either.
Exactly.
So that it's kind of a tit for tat.
The other piece of this that makes employers often really uncomfortable is an obligation to supply information relevant to the bargaining. And sometimes this can get into sort of questions of what's proprietary information, what's confidential, do I really have to provide this information? It can be very bargaining specific. Generally, you don't have to open your books. There are some circumstances. We'll talk about that in the future, Jen. What things that you can say that will obligate you to open your books that are probably don't need to be brought up in negotiations, so it's best to stay away from them anyway. But there is a duty that arises to essentially back up claims that you're making and provide information to help the union be able to reach an agreement with you. And then the other issue relates to unilateral changes in terms and conditions of employment. This is also a really sort of fully loaded issue here. And the idea is that you can't just, especially when you're in the middle of negotiations, you generally cannot go ahead and make a unilateral change, which means a one-sided change that you're on your own are making without conferring with or giving notice to the union.
Even things like the bonus at the end of the year.
Mm-hmm. Are you going to give employees the company turkey or not?
Yeah, exactly. That kind of stuff, you generally would go to the union first and say, hey, we want to give them a turkey. Is that okay?
Exactly.
I mean, it seems ridiculous, but everything is so sensitive when you're in this kind of stage. You need to be careful about putting the union on notice before you make a change. Mm-hmm. And that's one of the reasons, frankly, why employers want eventually an agreement too, in many cases, because then you don't have to go for every little thing to the union. You guys already talked about it. You've already decided what you're going to cover in that agreement and what the employer has retained as their right to
exactly
cover.
And you don't have to sit down and look at the union across the table. Sometimes it helps to have people in a room together, but often clients will have a good relationship with their unions and can just knock things out over the phone.
Yeah.
It helps to have a sort of base to work from at that point. We wouldn't necessarily recommend it for your first collective bargaining agreement, but maybe an extension or one that's continuing.
Yeah. So one of the questions was, do we have to sit down with them? Can we do this over the phone? All of those things that go into even how you're negotiating are negotiable, right? Which is frustrating. So you kind of have to negotiate beforehand how you're going to conduct negotiations. I have had unions push back on the over the phone. We do a lot of negotiating over the phone. And I've had unions push back. I've had unions file unfair labor practices. And I've had the NLRB saying if the union insists on seeing you face to face, you generally will have to go to where the employees are. So if you pick up a contract in Kansas and the union insists on seeing you in person, it could depend on the investigator you get, but I've had a couple of cases where they've said, no, you have to sit down with them in Kansas because that's where the employees are. But if you, like Sarah said, if you have a good relationship with the union, especially if it's not your first contract, most folks will say we can have a phone conversation and get some of this stuff off of the plate. Another question we had was, is the government, if you're on a government contract, is the government going to have to pay for any of these wage and benefit increases? Generally speaking, we run into this on Service Contract Act contracts, and that's what we're going to be talking about next week. So the teaser is generally, maybe, but there are a lot of rules that go into how to ensure that you are going to get that wage increase. Some of it's timing. Some of it's, did you negotiate at arm's length? Did you get things turned in on time? Are you within the realm of, like, this is reasonable? So we're going to talk about all that stuff next week. So I'm going to kind of leave it there with that particular question.
Mm-hmm. And then we also had a question, can the union distribute any documents received during negotiations? This goes towards what Nichole said, that everything's negotiable. So if you want to condition turning over some documents on the condition that the employee doesn't share them, the union doesn't share them outside of the bargaining room, you can do that. Sometimes unions are hesitant because they want a lot of transparency with their members. Employee rosters, generally, that was one of the questions that was asked. Do you have to allow the union to distribute those? And years of service, that's generally stuff that's going to be public, if not before the bargaining, then after the CBA, just by virtue of CBAs generally introducing a lot of sort of seniority rules. And so generally when you have a CBA, not all, but you're going to know the years of service of each person. So if you're worried about it going out now, I don't know if it's that big of a deal because it's going to come out one way or another.
And the standard is pretty high. So if you get into a fight with the union over confidentiality of a document that you want it to be confidential and you want the union to agree to it or sign some sort of confidentiality statement, the union's generally going to be hesitant to do that, and they may say, well, you have to give it to me anyway, and if you don't give it to me, I'm going to go to the NLRB. The standard at the NLRB is very high, and it's not just this wouldn't be a good thing to have out there. You've really got to have a significant justification for keeping that information closed off particularly from the unit. Mm-hmm. Finally, one more question, then we're going to move on, is there any way to let employees know if they're unhappy with the union and they're not liking the union, how to decertify? There is a decertification process. The challenge for employers here is that you don't want to exhibit what we call anti-union animus. So while employees, maybe you have a couple of employees complaining to you about the union and they don't like it and they don't want the union and et cetera, you want to be careful what you say to folks about your opinion of the union or your opinion of, what they should get and not get. What I generally recommend is that employers stay a little bit Switzerlandy here and say, if you're unhappy with the union, there is a process through the NLRB. You can go to the NLRB and somebody's going to help you with that. Because there is a lot of information online at the NLRB's website, investigators, there are folks at the NLRB that will help them. That way you don't have to say your opinion one way or the other. And if they want to start that process themselves, they can start the process themselves. There is some legislation that's been punted around recently about giving employers a little bit more control over that process, but my sense is that it's not going to go anywhere anytime soon.
One last part of this slide is that this sort of goes into when you have to know about this stuff versus when you don't. Obviously, we've gone over just because you don't have a unionized workforce doesn't mean the NLRA doesn't apply. The other instance where this could come up is where you're taking over a contract that a previous employer or previous contractor had, and it's a unionized workforce. And in those situations, assuming that you're employing most of the employees who are on the site and generally continuing operations in a same or similar fashion, then you're a successor contractor and you are obligated to either negotiate with the union or take on the previous CBA. And there's a bunch of case law out there that determines and distinguishes between the two. Generally, on an SCA contract, we have a question as to what extent you have to accept the contract that's there or are able to renegotiate. And this is something we'll get into next week when it comes to the SCA and CBAs and how you kind of consolidate the different laws. But you do not, assuming that you make clear that you're going to be starting off with new terms and conditions, you don't have to sign on to the new CBA. It's a little bit complicated because of the way the SCA works, some of the terms from the previous CBA are part of a wage determination, so you have to comply with those. But generally, you don't have to apply the whole contract, and you can negotiate a new one.
So what's common is that employers will go in and just, the union will say, well, just sign on to the last CBA. It's easy, you got to do it anyway, it was in the contract. Well, that's not entirely accurate, right? I mean, all you're required to do under the SCA is pay the wages and fringe benefits in the base year. In fact, in most instances, you shouldn't even be escalating your prices past the base year. And we can talk more about that next year, or next week, not next year. But generally speaking, you want to be very careful when the moment you get on site, to let employees know and to let that union know that your intent is to negotiate a new agreement. Because there's a lot packed into these agreements that can impact you other than the wages and fringe benefits. And it can be very costly to you if you're not paying attention to those things. And so I highly recommend you basically have a year then on that contract to negotiate with the union. You still have to negotiate in good faith, and you probably shouldn't wait the full year because you've got a deadline to turn a new CBA into the government. But you've got to have a new CBA with your name on it by the 30 days at least in advance of the next option year. So you should definitely think about what's in there. Now, everything in that contract is negotiable. Some things you're not going to have as much bargaining power on as other things. And, if you ever have a question about that, Sarah or I can very quickly walk through with you, where you should be focused in your negotiations. That's one of the things that we do all the time is help clients look at where they really should be focused, where they can kind of trim some fat, where they've really where they're kind of stuck. And so before you're even bidding on that opportunity, you should have a pretty good idea of the financial components in there. And it's really, really important, I can't stress enough, that you focus on this at the bidding stage. Because we get so many calls where you're stuck after the fact. Okay. So we're going to move on for a minute because otherwise we could talk about this all day, and we're going to talk about this again next week. But we really wanted to spend a little bit of time talking to you about the impact that the NLRA has on your practical business stuff, right? Like, why does all this Section 7 and Section 8 stuff matter, particularly if I'm not unionized, right? Like, why does it matter? So we want to talk about that real quick. First of all, hiring determinations, right? And I think I mentioned this earlier, but don't ask about affiliation with a labor organization during an interview. Just stay away from it. It's just as bad as asking somebody about what their religion they are, or, if they are politically affiliated with certain groups. State laws often protect that. So when should you bring up the topic of a union? If you have a union on site and that prospective employee is going to have to pay dues, I usually include that as part of the offer letter. So you're just not talking about it, right? It doesn't give you the opportunity to color that conversation. It's just kind of in the offer letter, and they can decide whether to take the offer or not. There really shouldn't be a case during the interview process where you're talking about opinions. Now, I suppose it's possible, and this happens, that an employee or prospective employee volunteers their opinions, right, about a unionized workforce. Maybe they think that they know that there's a union on site and they want to make sure that you know that they're not going to drink the Kool-Aid or something like that. And so they volunteer this information. Again, try to stay Switzerland. You really don't know what that person really feels. And the last thing you want is to hire that person on, and then all of a sudden they're talking to the entire workforce about all the awful things you said about the current group. So just try to stay away from it as much as you possibly can.
So this is sort of an overarching sort of topic of some more specific ones we'll get into, but basically the idea of promulgating or announcing new rules or regulations in the workforce. And if this is something that affects the terms or conditions of employment, and you're unionized, then you have to negotiate with the union before you do this. Sometimes there are some CBAs that don't touch on certain topics, in which case it becomes sort of confusing, right? Because you have the things that are regulated by the NLRA, and then once you get a CBA, the things that are regulated by that contract. And generally, once you have a CBA in place, most things are going to be falling under the CBA, but you can still run afoul of the act if you're directly dealing with employees to get around talking to the union, or if you're sort of making unilateral changes without giving notice to the union first. So that's important to know whenever you're going to put out a new rule. The other issue is even if there's no union on site, it could still be relevant because you don't want to interfere with employees' Section 7 rights again. And that's the right to talk, the right to discuss terms and conditions of employment, the right to vote, and all of those sort of that list of things that we covered earlier. And so different policies that might impact these rights are confidentiality policies, which we'll get into, social media policies, non-solicitation requirements. And so whenever you're sort of touching on these different subject matter areas, you want to make sure that you're not inadvertently including language that is violative of the act.
And we'll go into each of these more specifically now.
Yeah. Thank you for that lovely introduction. So regulating confidential information. Often we'll have employer policies that want to make sure that employees aren't sharing confidential information about the company. And there's a way to do this that sort of makes sure that you're actually interested in protecting the confidential information versus circumventing employees' Section 7 rights. And there's sort of some new evolution of this in the new board era where they're a little bit more lenient on policies that potentially could be read to be violative of NLRA rights. But basically, if you have a legitimate business reason and you have a policy that doesn't directly interfere with these rights, then it's probably okay to include it. And you want to make sure when you're, for example, issuing confidentiality provisions that you're not prohibiting employees from discussing their wages or their hours or whatever other issues might touch on their terms and conditions of employment. So you don't want to, for example, issue a rule that says, under no circumstances are employees allowed to talk about salary increases.
Or what their salary is. Or even one thing that we see in confidentiality policies a lot is a reference to the handbook and that this is confidential and proprietary information. Mm-hmm. Unfortunately, you can't, that's in a lot of cases that component, because it encapsulates your policies, can be shared with an NLRB agent or an even EEOC person. And so there's going to be scrutiny if your confidentiality policy basically says you can't share some of that information. Mm-hmm. Again, like Sarah said, there are ways that you can word craft around this, but don't just, copy and paste a confidentiality policy from a handbook you saw online into your own handbook without really scrutinizing what it prohibits. Mm-hmm.
I mean, best case scenario or least worst case scenario, the board's just going to say, fix it, delete this from your handbook. So the sort of consequences of including this language aren't that huge on the one hand. But on the other hand, you've got to deal with the headache of dealing with a board charge and an unfair labor practice. You have to deal with the headache of talking to the investigator, interviewing employees, making sure that employees weren't necessarily discouraged or dissuaded from discussing certain terms. And it's a lot easier if you just avoid that headache to begin with.
And a lot of times it's used, it's rare to get, unless we get it from like a union who doesn't like your policy, it's rare to get a ULP based on just handbook language, but we've seen a couple of them, particularly in the Obama era, which drew a lot of attention to this. But where we most often see it is coloring the employer as a bad guy or a bad company, right? So you'll see it in conjunction with another ULP or another something that's going on, and they say, look, this is just more evidence that these are bad actors.
And we just got a question. Are you talking about employees sharing with coworkers or agencies, or does this include employees not sharing their salary information with competing companies? I think that there's an argument that you could say you can't share your salary with a competitor because it's very clear that the business reason is to sort of make it so that other companies can't underbid or
particularly if you're, if you're a labor-centric business, then wages mean the world, right? So
on the one hand, yeah.
Yeah, but if you're talking about investigators or coworkers, then you can't prohibit that.
On the other hand, often with these contracts, salaries and wages are already sort of public information. I think you can make an argument that the type of work maybe, but it'd be hard. You could probably find a scenario where you could argue it's proprietary, but even with customers, often you're not allowed to keep employees from speaking to customers about their wages. That's often one of the big ways that employees unionize and get bargaining power, is sharing with customers their wages and why they want them to be higher.
I think we covered a lot of what's on this slide, but essentially just reinforces the idea that you want to have that legitimate business reason. You want to, a lot of confidentiality policies will have that carve out for publicly available information. And you always want to, if in doubt, put something in your confidentiality policy or in your handbook that basically says nothing in here is intended to interfere with your Section 7 rights. But that's often not enough on its own, but it's a good thing. It's something we can point to that says, look, if we have a squabble over a couple of words here, it's clear that that's not what we intended and that we were thinking about Section 7 rights when we drafted this thing. Social media is probably one of the big deals of the day, because so much is out on social media, right? And so the question I always get is, what's the line? So employees posting on Facebook, particularly if there are coworkers as friends on Facebook, but not always. I mean, there have been a couple of Facebook cases or posting cases where there weren't friends particularly on Facebook that were coworkers, but the board found that because they were attempting to engage in a conversation with others about their terms and conditions of employment, that what they posted there was protected. What's hard is that sometimes those posts involve a protected concerted activity component and you are close to violating our other policies component. So it's not always cut and dry. But if you have a blanket prohibition on using company logos on your in posts or graphics on social media, or you want to fire somebody because they said the supervisor is an absolute jerk and he makes everybody work overtime, those things all have protected concerted activity components. But what you do have is a legitimate interest in ensuring employee communications don't misrepresent you. And so your social media policy should err on the side of simple and basically saying, if you post something, you need to that involves the company, you need to make sure that you say that it's your views and not our views. And and you're not going to violate one of our other policies, like a discrimination or harassment policy or a bullying policy or something like that. But when you get one of those posts that it often involves supervisors, or it often involves how poorly you treat the company, or you see something on Glassdoor that you think is close to disparaging the company, and you can tell from the post who it is, that you need to be very, very careful with those things, and you should probably talk to somebody. Often there are things that we can do. If there's a disparaging or defamatory component, we can often take action, even if the person is no longer employed by you. But you need to make sure that we're staying away from things that can be very dicey. I was just at a conference with some of the bigger hotels in the area, and their general counsel is dealing with this all the time. They struggle with this day in and day out. So it happens. It's just the world we live in, and we have to be careful about it.
We sort of touched on this. I'll go over this slide quickly, but it's essentially what Nichole was talking about. If someone talks about a supervisor in sort of a negative or disrespectful way, it's possibly, depending on if it's concerted activity, protected by the act. And so you can't just fire someone, or at the very least, you should think very carefully about firing someone who's criticizing their supervisor about overtime, or the fact that they didn't give them a raise, or the fact that they made them clean a certain floor. These are all terms and conditions of employment that need to make you think, maybe I should think twice before taking some sort of disciplinary action. That said, it is perfectly fine to promulgate a rule that requires employees to be respectful and professional to coworkers, clients, and competitors. That's reasonable. You just don't want to over lawyer it by putting too many restrictions on.
And it's different than insubordination, right? So this is different from telling a supervisor, I'm not going to do that, or you don't pay me enough to do that, so I'm not going to do it. Like there is a nuanced component of it. But what often happens is that because supervisors aren't trained in this area of law, they're not thinking to themselves, oh, like this is a red flag, and they discipline somebody or send somebody home for going up to them and saying, you know, why are you scheduling us for overtime again? Like, can't we do this a different way? The law recognizes even some amount of heated discussion with a supervisor about these types of issues, because obviously everyone cares a lot about these issues. But there is a line that employees can't cross. They can't cuss. They can't be violent. They can't. I mean, there are lines that the board has set for this type of conduct.
There's also a saying that's act now, grieve later, that employees and unions will use. And that's sort of the idea. If they're refusing to do their job, even if they're upset about it, they still need to do their job. And there are ways that they can, there's maybe one exception for if it's unsafe. Even then, the bar is very high. The employee has to do their job. And so once you get into that spectrum of blatant insubordination or disregard for company rules, that's sort of different from how they go about engaging with their supervisor and being respectful.
Yeah, and just as a point of clarification, and it's nuanced on the slide, but it's important to point out, and we got a question about it, like, can you identify what would not be respectful or professional? That stuff is mainly, you can have a rule to be respectful or professional to coworkers, clients, and competitors. And what's important about that is that we didn't necessarily say supervisor. And I know that's a point of contention. Every time I point this out in a handbook, they say, but Nichole, the reality is that you just don't want the appearance in your documentation that you are going to discipline somebody, or if maybe a conversation goes a little bit off the rails about a raise or overtime, or, you know, how employees are being treated generally. It's best to assess that on a case-by-case basis. It's best to train your supervisors to stay calm, walk away from the situation. If they need to send somebody home for the day, send them home for the day for a cooling off period, and we'll assess it later and figure it out. Or send them back to work, and if they refuse to go to work, you know, then send them home. But then go to HR or go to somebody else in the company to really assess what should happen next. Supervisors should be discouraged from, you know, the instinct to say you're fired right on the floor, because there might be more there that we have to be aware of. Dress code. Dress code's always fun.
This usually comes up when employees are organizing or when they're already represented by a union. Basically, the idea is that under the Act, employees have a right generally to wear union insignia, which is pins, buttons, T-shirts, hats. The Act allows them, because essentially it's communication with other coworkers and customers and other sort of third parties about their terms and conditions of employment. There is a caveat here, a carve-out that limits this right in special circumstances. This is a term that's been defined by the board, and essentially it includes where employee safety is at risk, or like, for example, if you have to wear a safety hard hat and you choose to wear your union hat instead, the employer can say, no, put on your hard hat. You can't wear that in here because it's a safety issue. Also, with big pins, if you're in a manufacturing line or something, sometimes there's a danger that the pins will get stuck in the machinery. That's another special circumstance.
You also have the government sometimes getting involved.
Oh, yeah, that's a great special circumstance. Pretty much if the government says no, you're off the hook.
Yeah, so a lot of you are government contractors, and you have a government client, and we've had cases where the union will wear their T-shirts or hats, on the shuttle bus or whatever it is, and there are uniform and dress codes requirements that are imposed by the government, and that is kind of the end of that, and that's kind of falls in the legitimate business reason realm too.
And so it's a case-by-case basis. You want to make sure that you're not discriminating specifically against union-type stuff versus other stuff. So if they're allowed to wear pins and hats for some other reason, chances are they're going to be allowed to wear union hats.
All right. So other rules that are affected are, conduct to coworkers. There's a recognition that there can be very lively discussions between coworkers about terms and conditions of employment. When you have a media policy, it's very similar to your social media policy. Don't represent us. You can't generally prohibit people from talking to the media, but you can say you shall not do so on behalf of the company. Things like restricting employees from leaving work under certain circumstances, that might be a reason for discipline under some circumstances, but you want to be careful about how you promulgate those rules. Recordings and photography, conflict of interest rules, and we talked about the handbook. But it's not that you can't have policies prohibiting this stuff, but you have to be careful about how you do it. And occasionally we see recording and photography policies that are not particularly lawful. You want to take a look at those. How do you implement lawful policies? So you just want to make sure they're narrowly tailored. You want to explain your business reasons. It doesn't have to be a page or a dissertation, but it can be a very quick one line. This is the reason we do this. And then it helps employees understand too, so you're not always the bad guy. You want to apply your policies consistently, because that'll help you justify a termination or discipline when someone doesn't follow those policies. And then make sure you make it clear that it's not intended to interfere with their rights.
We've touched on a lot of this, but basically when you're looking at all employers, you want to make sure you're not discriminating based on Section 7 activity. This includes disciplining or terminating employees because they've been talking about their rights or exercising their rights. And you want to consider whether or not, essentially, by your action, you're chilling their right to speech or their right to organize. And specifically with unionized workforces, you are generally going to be bound by the collective bargaining agreement that you've signed with the union and with the employees. And generally under this, there will be a grievance procedure that's applicable, and you generally have to abide by what's called just cause discipline provisions. So you can only terminate or discipline someone for just cause, which essentially means that you've engaged in either progressive discipline or they engaged in some sort of behavior that's so egregious that it justifies summary termination. And that's sort of enough, I think, about that.
I think we've covered discipline, so I want to get to Weingarten Rights real quick because we just have a couple minutes left. But employees generally have Weingarten Rights if they are represented by a union, and there's reason to believe that an interview with an employer will lead or may lead to discipline, right? So the gist here is that if you are going to meet with an employee to investigate something that could lead to that employee being disciplined, or you need to ask, and you're asking them questions, the employee has a right to have a representation or representative present. It might be a union agent, it might be a shop steward, it might be somebody else. Again, this generally applies to a unionized workforce. There's a lot of gray area here, but employees can also forego their representation and proceed with the interview, but they have a right to do it. And what we generally tell employers is you probably want to err on the side of allowing them to have a representative present if they ask for it, because a lot of times you don't intend to go in asking people questions that could lead to discipline, but then it happens. And you don't want to be in a position where you have to like stop the interview because things are going a way that you didn't think they were going to go. So generally best to err on the side of caution there.
Mm-hmm. And just because we've been talking about all these violations and not much about the consequences, when someone does file an unfair labor practice with the board, they're essentially alleging that the employer or the union in some circumstances had violated the act. And what are the consequences of this violation? Generally, it can be back pay. If you terminated someone without, for a discriminatory reason, the board could require that you reinstate them and provide back wages through a certain period of time. It requires generally that you post a notice to employees that explains that you violated the act and that you promised essentially not to do so in the future. And it can also require certain policy changes. In some instances, they can require bargaining or even that you agree to certain terms in unusual circumstances.
So real quick, I know we're basically out of time, but up on your screen is the next two webinars. They are recorded as well and available to you. We hope you will join us. I know a lot of you are probably interested in next week, which will lead into the October 31st Happy Halloween webinar as well. We have a couple of questions we didn't get to, and we will email you. My hunch is that these will also often be covered next week. One of them I can tell you real quick is, do contract requirements fall under special circumstances? I would highly encourage you to actually look at what those contract requirements are, because often we make assumptions about what's in that contract. And then when Sarah and I go in and look, it's like, well, that's some version of that, but not exactly what we need. And I would say that probably falls more into a legitimate business reason more than a contract requirement, but it could be a special circumstance. But you want to really, really look at what does the contract actually require. For example, sometimes I'll get questions about removal of employees. Often that's not specifically spelled out in the contract. We just know that the government realistically can do it, and then we get in arguments with the union about it. So it's best to really carefully scrutinize those things. And finally, I'll cover this one. Do we have to ask the employee if they want a union rep, or are they responsible for asking? They are generally responsible for asking for the rep. If you think you're going to get sideways with somebody, it's probably not a bad idea sometimes to just say, just checking, but it's not technically your responsibility as the employer. Although they don't have to specifically say, can I have a union rep present? There's a number of different words that they can use to indicate to you that they want somebody present. So it's again one of those things where they don't have to specifically say the magic words for it to become an obligation. They just have to know enough to indicate that they might want somebody present. So with that, we're a few minutes over, and I apologize. We try our best to stay on time, but we hope that you will join us next week and the week after. We are looking forward to it and hope you have an excellent rest of your day.